Every single American woke up today in a different country than they went to sleep in last night. I know that sounds dramatic, but I need you to understand exactly what just happened. The Supreme Court of the United States just dropped a unanimous 9-0 decision that doesn't just affect gun owners. It doesn't just affect one state. It doesn't just affect one group of people. This ruling affects every man, woman, and child living in all 50 states, every U.S. territory, and every single jurisdiction in America. And if you don't know about it right now, you are already behind. Here's what makes this ruling different from every other Supreme Court decision you've heard about in the last decade. 9 justices. 9. All of them agreed. In a court that is deeply divided on almost every major issue, 9 justices looked at this case, looked at the arguments, looked at the Constitution, and said the same thing. That almost never happens. And the fact that it happened here tells you something enormous. It tells you that what state governments and lower courts across this country have been doing is so clearly wrong, so far outside the bounds of what the Constitution allows, that even the most ideologically divided court in modern history could not find a single vote to defend it. Not one. That is the legal equivalent of a nuclear strike. Before I break down exactly what this ruling means for you and your family, do me one thing right now. Hit that subscribe button and turn on notifications. I know you've heard that before, but here's why it genuinely matters this time. The legal landscape in America is shifting faster than at any point in the last 50 years. Supreme Court decisions are dropping, state laws are being challenged, and new rules are going into effect every single month. 90% of gun owners are operating on old information. They are following laws that may not technically exist anymore. They are leaving their rights at the door because nobody has told them the rules just changed. That is what this content exists to fix. Stay ahead of the curve, stay legal, and stay protected. Hit subscribe, turn on that bell, and let's get into it. Here's what just happened. The Supreme Court issued a unanimous ruling that fundamentally changes the relationship between federal and state governments and the individual rights of every American citizen. The case worked its way through the lower courts, was argued before the highest court in the land, and landed at a place nobody in the anti-rights camp expected. All 9 justices looked at it and said, enough. The way governments at every level have been treating constitutional rights is wrong, and it stops now. And when 9 justices say that together, there is no appeal, there is no workaround, there is no circuit split to hide behind. It is settled law for every court in America, effective immediately. The core of the decision comes down to something the Supreme Court has been building toward for years, starting with the foundation laid in Bruin and now taken much further. The idea is simple, but the implications are massive. When a government, whether that is the federal government, a state government, or even your local city council, wants to restrict or regulate a constitutional right, they cannot just do it because they feel like it. They cannot do it because a politician thinks it is a good idea. They cannot do it because a majority voted for it. They have to meet a very specific legal standard, and this new 9-0 ruling just made that standard stricter, clearer, and harder to get around than ever before in American history. Let me explain what that standard looks like in plain English, because this is the part that changes everything. The Supreme Court has now made it crystal clear that any law, regulation, or government action that touches a constitutional right has to be rooted in the historical traditions of this country. That means when the government wants to restrict something the Constitution protects, they have to go back to the founding era, back to the time when the Constitution and the Bill of Rights were written, and prove that similar restrictions existed back then. If they cannot find that historical proof, the restriction is unconstitutional. Period. End of discussion. You might be asking, why does this matter so much? Here is why. For decades, courts across America have been using a different approach. They have been doing what lawyers call interest balancing. A judge would look at your constitutional right on one side of the scale, look at the government's reason for restricting it on the other side, and then decide which one wins. And far too often, the government won. Courts would say things like, yes, this law restricts your rights, but the government has a really important reason. So that is okay. Judges would bring in social scientists to testify that banning certain things might reduce crime by 2%. And courts looking for any excuse to uphold the law would say, that sounds reasonable to them. The Supreme Court just looked at that entire process and said, stop. It does not matter how important the government's reason is. It does not matter how good their intentions are. If the restriction does not have deep historical roots going back to the founding era, it is unconstitutional and it must be struck down. Let that sink in for a second. The government now has to walk into court carrying a history book from 1791 and prove that the Founding Fathers would have agreed with their restriction. And here is the part that should genuinely shock you. Most of the laws restricting constitutional rights that have been passed in the last 30 years have absolutely zero historical basis in the 1700s or 1800s. Not close, not arguable, zero. By applying this 9-0 standard, The Supreme Court has effectively painted a target on a massive number of modern restrictions that have been sitting on the books for years, and Americans have just been quietly complying with them. The court also drew a hard line around how historical evidence can be used. States are already scrambling, literally hiring researchers to dig through 250-year-old archives trying to find a reason to keep their restrictions in place. But the Supreme Court made their job nearly impossible. The history the government points to has to be national and traditional. You cannot find one obscure law from a tiny mining camp in the Old West and call that a tradition. You cannot point to a law from a British colony before the Revolution and say it counts. It has to reflect a broad national pattern rooted in the American fabric, and in most cases that pattern simply does not exist for the kinds of restrictions that have become common in modern American life. Think about what that actually means in practice when a court is evaluating a challenged law. The judge asks two specific questions. First, does the plain text of the Constitution cover the conduct being regulated? If yes, the government has to clear the second hurdle, which is where they almost always collapse. They have to demonstrate that there is a historical tradition of banning or regulating that specific conduct going back to the founding era. Not a vague resemblance, not a distant cousin of a restriction, a genuine, well-established national tradition. And here is what states are discovering as they go digging through those archives. The silence is deafening. In 1791, you could carry a firearm into a tavern, a town square, a public market, a church. There were no background check requirements. There were no waiting periods designed to make the process so inconvenient that people simply gave up. There were no permit fees structured to price people out of exercising their rights. The founding era did not produce the kind of government gatekeeping apparatus that modern legislators have spent decades constructing. And because that apparatus has no historical analog, it is now on extremely shaky constitutional ground. Here's where this gets real for you personally. Think about the laws in your state that restrict where you can and cannot exercise your rights. Many states have created lists of so-called sensitive locations where constitutional rights are restricted or suspended entirely. Some of those restrictions make sense and have clear historical parallels. Government buildings and courthouses, for example, have a long tradition. But what about the others? What about restrictions that state legislators invented in the last 20 years because they thought it sounded reasonable at the time? States like New York, California, New Jersey, and Hawaii tried to turn this concept into something else entirely. They tried to declare essentially everywhere a sensitive location, stacking restriction on top of restriction, until a law-abiding person had almost nowhere left to exercise their rights. The 9-0 decision is shutting that strategy down. You cannot slap a sensitive label on a public sidewalk or a grocery store. The government has to prove there is a genuine historical tradition of restricting rights in that specific type of location. Since the 1700s did not have gun-free shopping malls or designated safe zones in public parks, the government is losing these cases one by one. And this is not just a blue state issue. That is something people in more permissive states sometimes miss about this ruling. There are laws in red states, purple states, and every state in between that cannot survive the new historical test either. Permit systems that require you to pay fees and prove need. Storage mandates that apply in ways that have no founding era precedent. Transportation restrictions that turn a routine drive into a legal minefield. This decision does not care about politics. It does not care which party passed the law or which governor signed it. The test is simple, and it is the same everywhere. Does this restriction on a constitutional right have roots in the founding era of this country? Yes or no? That is the entire analysis. And in jurisdiction after jurisdiction, the honest answer is no. Think about what that means practically. Imagine you are driving across state lines. Under the old system, you were a law-abiding citizen in 1 mile and a potential felon the next, caught in a patchwork of inconsistent, constantly shifting state laws. This 9-0 decision is a major step toward a national standard that treats your constitutional rights as primary rights, not second-class privileges that vary based on which side of a state border you happen to be standing on. The Second Amendment is not a lesser right that states can ignore because of their political climate, and the government cannot simply invent restrictions based on what feels reasonable in a given era. They are bound by history, and history is not on their side. Now here's the part that most people are not paying attention to yet, and it is arguably the most consequential piece of this entire ruling. This decision does not just change how courts evaluate new laws going forward, it changes the incentive structure for lawmakers themselves. Think about what that means. For years, legislators at every level of government operated with the knowledge that even if they passed a law that stretched constitutional boundaries, courts would likely give them the benefit of the doubt. Interest balancing gave lawmakers enormous latitude. As long as they could articulate some public safety justification, courts would often uphold their laws even when those laws clearly infringed on rights. That era is officially over. Now, if you pass a law that restricts a constitutional right and you cannot back it up with historical evidence, that law is going to get struck down in court. Having a signature law declared unconstitutional costs political capital. It generates legal fees, it generates bad press, and it opens the government up to liability for enforcing an unconstitutional law against citizens who suffered real harm as a result. The Supreme Court has essentially created a chilling effect on government overreach, and that is exactly the kind of structural check on government power that the Bill of Rights was always supposed to provide. Because this decision was unanimous, it is also acting as a green light for every constitutional rights organization in the country. Legal advocacy groups are already identifying the most vulnerable laws in every state and preparing to challenge them. They are not just targeting the headline laws. They are going after what you might call death by a thousand cuts regulations, the sensitive places overreach in states that tried to ban constitutional rights activity nearly everywhere, permit systems that require citizens to prove they have a good enough reason before the government allows them to exercise a right the Constitution already guarantees, home-built and modified equipment restrictions that have no historical analog, because in the founding era, building your own was often the only way Americans got equipment at all. These challenges are moving right now, and the legal direction is clear. We are also seeing an entirely new category of challenges emerging around what legal advocates are calling the common use standard. The Supreme Court has consistently held, going back to Heller, that the Constitution protects arms that are in common use for lawful purposes. This 9-0 ruling just gave that principle new teeth. Anti-rights legislators in certain states have tried to argue that some of the most widely owned firearms in the country are somehow unusual or dangerous in a legal sense, and therefore fall outside constitutional protection. The problem with that argument is that for something to be unusual, it has to actually be unusual. If tens of millions of Americans own it, if it is the most popular rifle category sold in the country, if it has been in common use for decades, the government does not get to redefine it as exotic just because they want to ban it. The American public, through their lawful purchasing decisions over generations, has already voted on what is in common use, and that vote carries constitutional weight under this ruling. There are 3 groups of Americans who are most immediately affected by this ruling, and chances are you fall into at least one of them. The first group is people who have already been charged with or convicted of violating laws that may now fail the constitutional test. If you or someone you know has been prosecuted under a law that cannot survive historical scrutiny, that case needs to be looked at again. Convictions can be challenged. Pending charges can be fought. This is not a small thing. We are potentially talking about thousands of cases across the country where the legal ground just shifted dramatically. The second group is people who have been denied rights, permits, or access because of laws or regulations that may not survive this new standard. If you have applied for something and been turned down, if you have been told a law prevents you from doing something the Constitution protects, this decision gives you a new and powerful argument, one that 9 justices just unanimously endorsed. Do not simply accept what a government official tells you. Make them prove the restriction is constitutional. Make them show the historical evidence. In a lot of cases, they will not be able to. The third group is the one most people are not thinking about, and it is the largest of the 3. It is everyday Americans going about their lives who are currently, unknowingly, operating under laws that restrict their constitutional rights without any legitimate historical basis. You may not even know which of your daily behaviors are shaped by laws that are now legally questionable. That is how thoroughly these restrictions have become woven into everyday American life. And that is exactly why decisions like this one are so important. It forces a reckoning. It forces governments to defend every restriction they have ever placed on your rights, and many of them, maybe most of them, will not be able to. But here is the warning you need to hear, because this is not a clean victory without complications. The Supreme Court was clear that the constitutional test does not protect everything. Even within this unanimous ruling, there is a framework that defines where the government can still act. Courts that find someone poses a credible, documented threat to the physical safety of others retain authority to act. That is the lesson from the Rahimi clarification, where the court unanimously held that individuals adjudicated as dangerous to others can be disarmed consistent with historical tradition. There is also the category of true sensitive places with genuine historical roots, and the category of prohibited persons whose disarmament reflects long-standing legal tradition. If you fall into one of those categories, this ruling does not help you and may actually work against you. Most Americans do not fall into those categories. But knowing where the lines are is just as important as knowing where you stand. Anti-gun governors and legislators are already on record saying they will fight this ruling. They are going to pass new laws specifically designed to test the boundaries of what the court will allow. They are going to hire historians to construct arguments that their restrictions have ancient roots. They are going to craft legislation that mimics historical frameworks while producing the same restrictive outcomes they have always wanted. Some of those arguments will fail, but some of them will succeed. And that means the legal landscape is going to keep shifting for months and years, not just days. There is also a more subtle form of resistance that you need to be aware of, and it is the one that catches most people off guard. Government agencies, at the state and local level, are going to continue enforcing laws even as those laws are being challenged in court. Until a court formally issues an injunction or a law is officially struck down, enforcement does not automatically stop. That means there will be a gap, sometimes a significant one, between when a law becomes legally vulnerable and when it stops being enforced on the street. During that gap, people get charged, people get their property seized, people have their rights violated under the color of a law that is already dying in court. That is a reality of how the legal system works, and being aware of it is part of protecting yourself in this environment. Knowing which laws are currently under active challenge and which ones have been formally stayed is not just interesting legal trivia. It is practical, protective information that could affect real decisions you make in your daily life. Subscribe right now if you have not already. The reason is not abstract. It is because this channel tracks exactly that information. When a court issues a stay on a major law in your state, you are going to want to know about it the same day it happens, not 3 weeks later when word finally filters down through mainstream news coverage that is already behind the curve. The organizations on the front lines of this fight move fast. The courts move fast when they want to, and the people trying to walk back this ruling are going to move even faster. Staying subscribed and keeping notifications on is the single most practical thing you can do right now to stay ahead of it. This is exactly why staying informed is not optional right now. It is a responsibility, because the people on the other side of this fight are organized, they are funded, and they are not stopping. If you assume a 9-0 Supreme Court victory means the battle is over, you will wake up one day to find that the ground you thought you won has quietly been reclaimed through new laws, creative legal arguments, and bureaucratic workarounds. Knowledge is not just power in this environment, it is protection. So here is what you need to do right now practically to make this ruling work for you. First, check the current legal status of laws in your state. Because of these rulings, dozens of state laws are currently stayed, meaning they are not being enforced, while lawsuits move forward. Organizations like the Firearms Policy Coalition and Gun Owners of America are tracking which laws have been frozen or struck down in real time. Check with them before you assume the old rules still apply. Police departments are frequently among the last institutions to be updated when a law has been stayed or struck down. If an officer references a restriction, ask them to cite the specific statute they are relying on. You have the right to know what legal authority is being invoked, and under this new standard, the government bears the burden of proving that authority is constitutional. That burden has now shifted in your favor in a way it never had before. Second, if you have been denied a right, a permit, or access because of a law that may not survive historical scrutiny, document it. Write it down, date it, get the name of the official involved if you can. Individual documented experiences of harm are often exactly how broad constitutional challenges begin. Your situation may feel too small to matter. It is not. Class action cases and group constitutional challenges are built from exactly the kind of evidence you might be sitting on right now. Lawyers and advocacy organizations need plaintiffs. They need documented examples of real harm caused by laws that cannot pass constitutional muster. If you have been affected, your experience has value in this legal battle. Third, stay connected to what is happening in the courts over the next 60 to 90 days. We are currently inside a window of opportunity that the Supreme Court has opened, but windows do not stay open indefinitely. Legislatures are already drafting responses. State attorneys general are already evaluating which of their laws are most exposed and deciding how aggressively to defend them. The next few months are going to determine how much of this constitutional ground actually gets reclaimed and how much of it gets quietly walked back through new legislation designed to survive the historical test while achieving the same restrictive outcomes. Paying attention right now is not a casual suggestion. It is the difference between knowing your rights and unknowingly surrendering them. Here's the bottom line, and I want you to hear this clearly. The Supreme Court just issued a unanimous decision that resets the relationship between government power and individual constitutional rights. It raises the bar for every restriction on every right in every state. It arms citizens and legal advocates with the most powerful constitutional tool this country has seen in a generation. It removes the comfort zone that lawmakers have operated in for decades, the ability to pass a law that sounds reasonable and trust that courts will defer to their judgment. That deference is gone, and it sets the stage for the most significant period of constitutional litigation since the Civil Rights era. The importance of that last point cannot be overstated. The Civil Rights era comparison is not hyperbole. That was a period when the Supreme Court forced a fundamental reckoning with laws that had been on the books for generations, laws that people had simply accepted as the way things were. It took years of sustained legal battles, case by case, state by state, to translate those Supreme Court decisions into lived reality on the ground. What we are entering now follows the same pattern. This 910 decision is the constitutional foundation. The work of actually translating it into changed laws, dropped charges, restored rights, and rewritten regulations is going to unfold over the next several years. And the Americans who are paying attention right now, who understand what the ruling says and what it means, are the ones who are going to be positioned to benefit from it as that process unfolds. If you own property, raise children, run a business, practice a religion, speak your mind in public, or do anything that a government has ever tried to regulate or restrict, this ruling affects you. Not someday, right now. A unanimous Supreme Court just told every level of government in America that your rights are not negotiable, that good intentions are not enough, that public safety arguments without historical foundation do not override the Constitution, and that the burden of proof now sits squarely on the government, not on you. Do not be passive about this. Do not assume a court victory automatically translates into protected rights in your daily life. The people who want to restrict your constitutional freedoms are not passive. Stay informed, stay engaged, and stay ready to defend what this ruling just reaffirmed. Subscribe right now and turn on notifications so you catch every update as this legal battle continues to unfold. Share this with someone who is still living in the pre-9/0 world, still following restrictions that may no longer have any legal standing. The fight for your constitutional rights just entered a new chapter. Stay in it. This content is for educational purposes only and does not constitute legal advice. Your specific circumstances require guidance from a qualified attorney who understands constitutional law and the laws of your state. Please consult a licensed attorney before making any legal decisions based on the information presented here.